for the petitioner, my lord, item number 47 and 51.
I appear for the Madrasa Service Commission in all the matters. And the lead matter is supposed to be, as Lordship indicated, WPA 24588.
If any additional point is required to be submitted,
Absolutely, absolutely.
then my lord,
It will be a lead matter. Otherwise, I will.
yes, yes, yes. Grateful, my lord. Grateful.
Item number 52, my lord. I have that completely different matter from my
You are supporting the madrasa.
If I
supporting. I have a different cause of action, but yes,
It will be taken care of.
Regarding additional point, we have some additional.
not additional point. I have a point regarding
All point will be care.
And there is a can which is kind of filed along with their matter.
Yes, yes.
as এখানে স্যার আমি তো আদার সাইড ও তোমাদেরকে লিড করছে না দ্যাটস গুড
17.
অনিন্দ
Who will argue this case? Where is he? You start.
I understand that this will continue.
yes
Deep development. Deep development.
কোথায় আছে এটা তো ফিক্স ছিল কোথায় চলে গেল
My item 44 is the my Onindo Bosch. There are 45 petitioners before my lord. In item 44, my lord, is the lead matter, my lord. But
Item number 44.
yes, my lord, WPA 24588 of 2024.
24588 of 2024.
My lord,
Where the subject matter of challenge is the notice dated 5/8/2024
5824,
and notice dated
9th
9/8/2024.
August 2024.
Very good. Make your submission.
My lord, there are 45 writ petitioners before my lord, who had participated in past state level selection test non-teaching 2010 for the post of Group D staff. My lord, the petitioner appeared in the preliminary examination, which were held, my lord, in 3 phases, my lord. In session 1, that is from 11 AM to 12 PM. Session 2, my lord, from 1 PM to 2 PM. Thereafter, my lord, as session 3, my lord, 3 PM to 4 PM, my lord, which was held on, my lord, 28 November 2010, my lord.
Date is
But 28 November 2010.
yes.
Thereafter, my lord, on the basis of the preliminary examination, my lord, written examination was conducted by the commission on 29th May 2011, where all the
So 28/11/2010 is a screening test.
preliminary
Preliminary exam.
screening test.
Give me a second. What is the name of the second phase of examination?
my lord, the written test, my lord.
Date?
My lord, on 29th May 2011.
29th May 2011.
11.
Very good.
My lord.
Then
Thereafter, my lord, after my lord, the written examination, my lord, since the evaluation of the answer script in respect of written examination was not been done, a writ petition was taken out at the instance of Sri Shoumen Malakar before this honorable court. But the WPA my lord 1722 of 2018 my lord. My lord, wherein my lord, an order was passed
that is at page number 64.
64 my lord. My lord, may I read for lordship my lord? But Mr. Devan, learned advocate, appearing with
Come to the 65 second paragraph.
no, my lord, one thing. My lord, here, my lord, in the report, my lord, may I read for lord? In the report, the reason for not publishing the result of the written test has been given as follows: that the result of the written examination of first state level selection test non-teaching group T is yet to be published, as instruction has been sought by the West Bengal Madrasa Service Commission from Minority Affairs and Madrasa Education Department, Government of West Bengal in the matter, and the Minority Affairs and Madrasa Education Department, Government of West Bengal did not give any instruction to the commission.
So commission has sought for an instruction from the department,
Yes,
and
my
the
lord.
department has not given instruction.
Instruction
That report was furnished before the single bench.
before the honorable coordinate bench, my lord. My lord, thereafter, my lord, the honorable coordinate bench has held that since in terms of the rule 17, it does not provide that it is mandatory, it is not required,
Instructions are required.
not required as per my lord, the recruitment rules.
Rule 17 does not show that whenever a written test has been held, such instructions are required.
My lord. And accordingly, the present writ petition is disposed of on or of after recording that writ petitioner did appear in the examination of first state level selection test group D on May 29 2011 and not March 27 2011 as submitted by both the learned advocate for the petitioner and Mr. Diwan, learned advocate for the commission, and by directing the respondent number 2 and 3 to forthwith intimate to the petitioner the result of the evaluation on the answer scripts, and if he is qualified, then to prepare the panel in terms of rule 18 of the said rules, and he is eligible as qualified candidate in terms of such list of candidates, then the said respondent shall issue invitation letter to him for personality test in terms of rule 19. No instruction will be required from the state of West Bengal for completing this exercise. But the report is required, my lord. But it is for I shall place before my lord, this report is my lord, the required, my lord. Since they have taken this point before the honorable coordinate bench, that since the state government did not provide the instruction, my lord, they did not publish the result of the written examination, but in the comprehensive affidavit, my lord, they have taken a different stand. That's why, my lord, this report is, my lord, is important, my lord.
In the comprehensive
They have
affidavit,
taken
as
a,
used in here.
yeah, my lord, they have taken a different stand. That's why, my lord, this report is, but since they cannot take a different stand in the before the honorable coordinate bench, they have stated, my lord, that since the state has, my lord, did not give any, my lord, the instruction, my lord, they did not publish the.
So according to him, they were awaiting for the written instruction from the department.
But in the affidavit, my lord, they have taken a different stand. That's why.
Which affidavit?
But they presently they have which they have.
Composite affidavit as
Yes,
filed
ma'am.
in connection with the instant writ petition.
Yes.
Very good.
No instruction will be required from the state of West Bengal for completing this exercise. The entire exercise as aforesaid shall be completed.
That is the finding of the coordinate bench.
No.
No instruction is required.
Yes, my lord, but the stand taken by the commission, kindly appreciate, my lord. They have the stand taken by the commission, and the report was filed that since the state government did not provide them the instruction, they did not publish the.
I understand, but as per the order of the honorable single bench, there is a coordinate bench. The coordinate bench holds that no such instruction is required. And therefore you publish the result by such and
Mal
such.
kindly appreciate, Mal, I am making this submission on the ground, Malad, since they have taken a stand that since the state government did not give them permission, they did not publish the result of the written examination. But they have taken a different stand in the affidavit that there's something, Malad, that since Malad, the session 1 and session the preliminary examination in respect of session 1 and session 3 was held by considering the answer sheet of session 2. That's why, my lord, they did not publish the result of the written examination. That is a different stand, my lord. That's why.
We'll consider that.
Yes.
Very good.
But the challenging, my lord, that, my lord, the commission, my lord, has preferred the NAP, intra-court writ appeal before the Honorable Division Bench, page 67.
They never took the stand. The fresh examination has to be taken. Any point of time in which they have never taken that stand. Because it's normal
After thought,
intercourt.
okay.
After 8 applications and the 8
Yes.
My lord, the intra-court writ appeal, my lord, page 67 is the order passed by, my lord, the Honorable Division Bench. My lord, the challenge to the impugned order was made on multiple grounds, but on the last occasion, leave was sought by the appellant.
You said that you were led by Mr. Mojumdar.
Yes, my lord.
Mr. Mojumdar, where is Mr. Mojumdar?
He is just coming, my lord.
But I will not allow Mr. Mojumdar to argue which you have argued.
No. He shall make additional submission.
If you think that he will consume such time,
No.
that I will not allow.
No. Thank you.
What happened?
Yes,
What
ma'am.
is your You're looking so frightened. You're making me frightened.
No.
Yes, sir.
Yes, ma'am. My lord, the writ petition was filed by the respondent one assailing the inaction on the part of that was recorded that is yet to be published, and the reason for non-publication was shown as lack of instruction from the minority affairs and Madras.
You are reading from which portion, sir?
Second paragraph, last line, my lord.
Yes. Kindly place.
My lord, the writ petition was filed by the respondent number one assailing the inaction on the part
Respondent number 1 is the Madrasa Commission.
Madrasa Commission.
Yes.
Assailing the inaction on the part of the West Bengal Madrasa Service Commission in publishing the result of the written test. The report was called for and it was opined by the commission that the written examination of the first state level selection test non-teaching group T is yet to be published, and the reason for non-publication was shown as lack of instruction from the Minority Affairs and Madrasa Education Department, Government of West Bengal.
Mr. Mojumdar has come.
Yes,
Your lordship had your lordship.
Mr. Ghosh has stated that the writ petitioners were participating in the preliminary examination as held on 28/11/2010. He also argued that the petitioner participated in the written test as held on 29/5/2011. He also referred the learned coordinate bench order as is available at page number 64 to 66. Now he is placing the division bench order. Now you take the battle.
Your lordship's interim order probably crystallizes the issue. Please have a look at the interim order passed by your lordship. মহা মুশকিল তোমাদের এখানে।
এই অর্ডার শিটটা দেখি ভাই।
তিনবার পরে জানি নাকি প্রচন্ড কষ্ট।
My order passed it during last puja vacation.
Yes.
Order dated, sir?
14th October.
14th October 20.
14th of passed in connection with
But in this petition,
No.
Abdul Latif. Abdul Latif is 14th October 2024 with Habib Mondol and all this.
14th October. फोर्टीन অক্টোবরে তো মামলার এখানে অর্ডার শিট নেই করলেন 14th অক্টোবর অর্ডারটা it was passed in connection with
This was passed in connection with WPA 25438 Abdul Latif and others versus state with Muhammad Habib
25438
Yes, ma'am.
ওইটা পার করুন তাহলে ওইখানে হয়তো থাকতে পারে
আপনাদের এফিডেভিট অপোজিশন আছে
তিনবার বলেছি আলাদা করে রাখতে একসঙ্গে থাকলে সুবিধা।
অর্ডার বুক গুলো আলাদা করবেন। না, এটা নেই।
কিন্তু আমি বলেছি রাখছি আমরা দেখলাম।
ঠিক আছে, ঠিক আছে, পরে পরে পরে।
আমার দিকটা থেকে দাও তো, আমার দিক থেকে একটু বাজেটটা দাও। Has your lordship kindly got that?
Give me a second. Yes.
Follow. By filing the instant writ petition,
Oh, you appeared. On that day, you appeared, I believe.
the writ petitioners have challenged the legality, validity, and correctness of memo dated 5th August 2024, as published by the West Bengal Madrasa Service Commission, whereby and whereunder 73,978 candidates have been asked to participate in the written test scheduled to be held on September 1, 2024 for selection of successful candidates in first SLST non-teaching Group D. Learned advocate appearing for the writ petitioners at the very outset draws attention of this court to an order of 23rd July 2018 passed by a coordinate bench in Shaumen Malakar. Attention of this court is also drawn to the order dated February 4, 2020 passed by a division bench of this court in mat number so and so. There's the Madrasa Commission's appellate order which Mr. Bose has placed before your lordship. It is submitted that the order of the learned single bench dated July 23rd, 2018 was assailed before the division bench in mat number 907 of 2018, whereby and wherein the division bench by its order dated February 4, 2020, while disposing of the said writ appeal and while rejecting the said interlocutory application, did not grant permission to the West Bengal Madrasa Commission to take further written test in respect of the said examination. That's my submission. It is also submitted that the impugned notice dated 5th August 2024 is contrary to the spirit of the order of the division bench and that the same is required to be stayed. While opposing such contention, learned advocate for the West Bengal Madrasa Service Commission submits before this court that the present writ petitioners being unsuccessful candidates have no locus standi to challenge the said notification of August 5, 2024. That's the first objection. It is further submitted that in the previous round of litigations, the present writ petitioners were not the parties and therefore they cannot take advantage of the order passed by the division bench. Now, this is something which your lordship will kindly consider, keeping in mind that it's a question of finalization of a process. It is also submitted, that's the learned counsel for the commission, that pursuant to the said notification, written examination has already been conducted and the merit list has already been published in respect of the successful candidates. On perusal of the entire materials placed before this court, and after hearing learned counsel for the contending parties, it is not in dispute that the subject matter of the instant litigation and the subject of the earlier round of litigations is identical, which is with regard to the recruitment examination of the first SLST Group D. In course of hearing, learned advocate for the commission made an attempt to distinguish the facts of the instant case with the facts involved in the earlier round of litigations. Since in the earlier round of litigations, the writ petitioner is different from the present writ petitioners. From the order of July 23rd, 2018 passed by the coordinate bench in WP 2018 and the order dated February 4, 2020 passed by the division bench in mat so and of 2018, it appears to this court, at least prima facie, that in course of the earlier round of litigations on behalf of the Madrasa Commission, an application was filed for extension of time to complete the recruitment process, and in disposing of the said application along with the said appeal, the division bench took the following view. We would have proceeded to reject the said application, but considering the plight of the candidates who have participated in the written examination and because of the careless conduct of the authorities, their fate is still in large or in other words uncertain. We feel that the authorities must act strictly in terms of the order passed by the single bench as affirmed by the division bench. We are unable to comprehend the stand of the appellant that further written test is required to be conducted.
when the same was not accepted by the single bench as well as the division bench, and the direction was plain and simple that after conducting the written examination, the answer scripts are to be evaluated and the panel is required to be prepared indicating the successful candidates. On perusal of the aforementioned order, it thus appears to this court, while disposing of the said appeal, that the division bench did not permit the commission to conduct further written test in respect of the aforementioned recruitment examination. Admittedly, the present petitioners were not the writ petitioners in the earlier round of litigations. By taking advantage of the same, in considered view of this court, the commission cannot be permitted to take any further written examination in respect of the aforementioned examination, which was sought to be done by issuing the letter dated August 5, 2024, and which is under challenge before this court. It is submitted at the bar that in the meantime, the written test has already been conducted and the list has been published with regard to the successful candidates in the written test held on September 1, 2024. Such being the position, this court considers that the petitioners are successful in making out the prima facie case for obtaining an order of stay. This court further considers that in the event the stay order as prayed for is not passed, the writ petitioners may suffer irreparable loss and injury, especially when the balance of convenience is in favor of the writ petitioners. In view of such, the commissioner is hereby directed not to proceed any further pursuant to the notice of August 5, 2024 till so and so date or until further order whichever is earlier. The writ petition is required to be heard on merits, then not directions for exchange of affidavits. So, two things were addressed at the interim stage. One, whether at our instance the writ petition could be maintained, and number two, whether the situation warranted taking of a second examination, and apropos the observation or not the intent of the order passed by the Honorable Division Bench. But according to us, not the Division Bench order has sealed the fate of the Commission in taking a second examination. Not in not same process, not came to be considered at the interim stage by our coordinate bench.
The final hearing of a matter, the interim order is not to be seen, not to be placed.
Your lordships will consider not whether
No, all interim orders will merge with the final order.
Because the interim order, they may march, may not march. But the
Very
interim order is not to be
I
seen.
shall consider. Yes.
Not even not the law is well settled that even not a judgment which is set aside facts recorded in the order are to be looked into.
I believe this order, upon this order, an application is also filed.
Not I'll show the nature of the application.
Yes, yes. For modification of the order, something like that.
In another writ petition, there is an application for
Yes, yes, I know, I know.
which restricts the commission stand to 9 seats only. 25th November 2024. The petitioners seek conclusion
Give me a second.
We have filed an application, Lordship, because this order, after creation of our right, once the right have been acted in our favor, we have filed the application because of this interim order. We were being affected. That's why.
Yes, Mr. Moyunder.
The petitioners seek conclusion of the selection process. Selection process. It appears that the initial written test was held in the year 2011. The said selection process is yet to be concluded. The petitioners pray for conclusion. Learned Senior Counsel representing the Commission submits that only counselling process is pending. The Honorable Division Bench in Matt so and so specifically observed that the authority must act strictly in terms of the order passed by the single bench as affirmed by the Honorable Division Bench. It was further observed that the bench is unable to comprehend the stand of the applicant madrasa that further written test is required to be conducted when the same was not accepted by the Honorable Bench as well as the Honorable Division Bench. The Commission, for some reason or the other, is not concluding the selection process and is contemplating holding further written test in respect of 73,978 candidates. It is in a further writ petition being Abdul Latif, not the order that I placed just now. A coordinate bench video order dated 14th October 2024 restrained the commission from proceeding any further pursuant to the notice of August 5, 2024 till December 13, 2024 or until further order whichever is earlier. As it appears that written examination in connection with the selection process of the year 2010 was taken in the year 2011, it is high time that the final result of the selection after conducting counselling be published by the commission without any further delay. The commission shall proceed to conclude the selection test of the year 2010 without taking any fresh written test in respect of any other candidate in terms of the notice of August 5, 2024.
It is a final order or interim
Interim
order?
order. Both are interim orders. Now, commission has come up with two stand. আমাদের অপোজিশনটা দাও আমার briefটা কোথায় ছিল?
So, Mr. Mojumdar, what is then prior to go to the commission stand, what is your stand? Pursuant to the order of the coordinate bench as well as the division bench,
Implement the same.
they have got no authority to take any further examination. That is your contention.
When the honorable
Therefore, the subsequent two notices regarding taking of examination, further examination is bad in law.
But that is not under challenge. No examination has been challenged.
Yes, yes,
No,
under
no,
challenge.
These are, yes, the notice is challenged. If the notice goes, the examination goes.
That is under challenge. That is under challenge. That is the subject matter of the writ petition.
what is the situation? Let us consider the position not very practical. 297 vacancies. Certain number of examinees or candidates had participated in an examination process. A preliminary examination which has to be effectively concluded through publication of a merit list and counseling. That's 2010 examination process, examination held in 2011, concluded till 2024, nothing happens. And parties have to approach the court for expeditious disposal of the selection process. As and when parties approach the court for the purpose of expeditious conclusion of the 2011 examination process, commission hurriedly finds out that no, 12 years back, there might have been some error on our part arising out of a technical error.
Which was not brought to the notice of the earlier
court.
division bench.
And but this could not have been done. First of all, whether commission has reserved.
Mr. Mohindar, so far as what I have gone through, that after passing of the order of the single bench and after passing of the order in the division bench, disposing the appeal and thereafter extending time on the prayer of the commission, has it been ever disclosed to the honorable division bench that on account of subsequent facts as which are subject matter of the
Surface.
instant writ petition, we need further time?
No. The stand taken as it appears from the order of the honorable division bench is give us some time, we shall comply. Comply would mean without taking a further test.
So before the honorable division bench, even after disposal of the appeal and even at the time of file successive applications for extension of time to publish the final result on the basis of the written test as held in the year 2011, the commission never came forward with a plea that certain persons have been left out. Am I correct? It is your contention.
But that's the succinct point. Now, effectively, two things surface from the stand taken in the comprehensive affidavit in opposition used by Madrasa Commission.
ওটা একটু দিতে হবে আমাকে comprehensive. It has been filed
in connection with
yeah.
Muhammad Habil 24588. এরকম
এটা বার করে দাও।
এদিকে দেখো
এটা তো রিট পিটিশন আছে।
in the back sheet of মধুরিমা সরকার।
বার করো। এটা আছে নাকি? আমি বলেছি বারবার অর্ডার শিট আলাদা করুন।
আর এই মামলা ডিটেইল।
ও আচ্ছা আচ্ছা। এইটা কি করে বার করবো? খুলে দাও কাটলেই কেলেঙ্কারি হয়ে যাবে। ওনার মুখটা বারবার বলি আলাদা করতে। করাতে তো হবে, নট নাও, এখন করো না। Yes, Mr. Mujumdar.
Please come to note page 11 of the said opposition. That 1,92,241 candidates applied for first SLST 2010, but only 1,43,303 applicants had participated in the preliminary screening examination. Pausing here for a moment, your lordship remembers that before the honorable division bench, the stand was many candidates had appeared. That there was the specific observation made by the honorable court in that order of the division. I shall once again revert to that. The preliminary screening examination was held in 3 sessions, being session 1, 2, and 3. In session 1, 46,052 candidates. In session 2, 47,643 candidates. And in session 3, 49,608 candidates had participated in the said preliminary screening examination for the post of Group D on 28/11/2010. Out of 1,43,303 candidates who participated in the preliminary screening examination, 26,445 candidates were declared qualified in the written examination. Out of 26,445 candidates, 24,577 candidates had participated in the written examination held on 29th of May 2011.
Out of these 24,507 candidates, one person has approached before the coordinate bench in earlier round of litigation.
Shomen Talukdar was one of them. Malakar, I'm sorry, Shomen Malakar. That after the written examination and during the processing the result of the said examination, so 2011 examination result is being processed. It was detected that the OMR sheets of all the 3 sessions, that is session 1, 2, and 3, were evaluated with the answer key of session 2 only, and as a result whereof, it was revealed that OMR sheets of session 1 and session 3 of preliminary screening examination were not properly evaluated due to technical fault in evaluation of OMR sheets. Please see. First, there was a preliminary examination, preliminary screening examination. The previous paragraph, paragraph D. So and so candidates had participated in
Held
the
on 28/11/2010.
Yes. Then out of 26,445 candidates, 24,577 candidates had participated in the subsequent written examination in 2011. Now, Commission wants to believe this court that in 2024 or 2025, in compliance of the Honorable Division Bench order, they were scrutinizing the preliminary examination results, which was a stage ahead, a stage anterior to the written
Mr.
examination.
Mujumdar, my specific question, sorry for the repetition.
Please.
As I have seen, I have gone through the files. My specific question is that during the pendency of the appeal before the division bench and after disposal of the appeal and in course of filing successive 3 applications praying for extension of time, such alleged flaws have been brought to the notice of the division bench.
Never.
In this composite affidavit, has it been declared by the, has it been disclosed by the commission as to on which day or within which particular period such flaw was detected?
Nothing. But I have showed your lordship page 11. But The stand taken. এবার করিয়েছো। আর আমার না কোর্টের রেকর্ড থেকে
Yes, Mr. Manjunath. Next.
Now, then the commission comes with the explanation that the virus of certain provisions of the Madrasa Act were challenged before the Honorable Court, which ultimately had traversed up to the Honorable Supreme Court. Then please come to page 18.
Page number
18 of the affidavit. The paragraph L, the second paragraph on the first subparagraph on that page, that the commission could not continue with the said recruitment process due to prolonged lockdown of COVID-19. The commission filed further applications being Can 8 and Can 9 of 21, seeking another 6 months time to conclude such process. Now that's
before the Honorable Division Bench.
so that's a final answer to your Lordship's query. The process, the said applications were moved on 12th September 23 and the same were allowed by this Honorable Court by granting 6 months further time to complete the selection process for the post of Group D. On 12/9/23, the learned advocate for the commission submitted before the Honorable Division Bench that an affidavit disclosing the technical errors of the commission in evaluating the OMR sheets of session 1 and session 3 had been disclosed in paragraph I in the said affidavit in connection with WPA of so and so Osman Ali Shah in another case. Crave leave to produce the affidavit.
Just a minute. What does it mean? On 12/9/2000, an advocate for the respondent submitted before this Honorable Court then an affidavit disclosing the technical errors of the evaluating were in connection with which matter?
Osman Ali Shah versus State of West Bengal. That is another matter.
Another matter.
Another matter.
Before the division bench, it was not yet over.
No, that's the what has been pleaded is the learned advocate had submitted this. But I don't find any such submission recorded though.
As the copy of the affidavit has been annexed.
Not crave leave to produce the affidavit. Then please see paragraph M. That after 12th September 23, the commission again started the process of re-evaluation of the OMR sheets of all the sessions of the preliminary examination. But there were two examinations, one preliminary, one written. For the post of Group D held on 28/11/2010 with proper answer key of those respective sessions, and thereafter it was detected that 73,978 candidates who had appeared in the preliminary screening examination for the post of Group D on 28/11/2010 were eligible for written examination held on 29/5/2011, but had not been allowed to sit in the said written examination held on 29/5/2011 due to the technical error of the commission as stated herein above. The commission could not complete the whole process due to Lok Sabha election. Then the skipping over one or two lines.
Mr. Mujumdar, just a minute. Article 6. 13(6) The last order was passed in MAT 907 of 2018 on 13/6/2024. Am I correct, Mr. Mujumdar? Whereby the division bench granted 3 months time to publish the result.
My lord.
as directed by the coordinate bench. Am I correct, Mr. Majumdar? So 13.6 means the commission ought to have disclosed, ought to have published the result by 12/9/2024. Has it been further extended? So by 12/9/2024, the commission published the result.
So not we approached this court praying for implementation of directions passed by the honorable court in earlier round.
Mr. Dhar, your client deposited the cost of rupees 2 lakh with the authority.
I'm told yes.
Yes, then. Sorry, Mr. Mithan. Place paragraph number M. What is your contention with regard to M?
Yes, not I was placing M, paragraph M.
Page number 19.
Again started the process of re-evaluation of the OMR sheets of all the sessions of the preliminary examination for the post of Group D held on 20th November 2010 with proper answer key of the respective sessions, and thereafter it was detected that 73,978 candidates who had appeared in the preliminary screening examination for the posts of Group D on 28/11/2010 were eligible for written examination held on 29/5/2011 but had not been allowed to sit in the said written examination held on 29/5/2011 due to the technical error of the commission as stated herein above. And your lordship has perused that paragraph M. Now please keep this paragraph beside page 74 of my writ application, the division bench order. Has your lordship got that?
Give me a second. Page number
74
of the writ petition.
of the writ petition.
Yes.
Paragraph 12.
Yes.
The cascading effect of permitting the litigant to take a different stand at different stages is that the litigation would remain open and it would augment and encourage the litigations to travel in the docket of the court, and there will not be any certainty in the rights claimed by the parties. We are unable to accept the contention of the applicant that a plea was taken that there has been a large discrepancy in the scrutiny process, and therefore the authorities have decided to make a fresh scrutiny so as to invite several other eligible candidates to participate in the written examination. But although not specifically said, what was the session 1, session 2 or session 3, but paragraph 13 squarely turns down any such plea.
So according to you, the division bench, while passing this judgment or order, has practically sealed the hands of the commission to go to for effecting any further.
Scrutiny of any nature whatsoever. Now paragraph 14. Such plea having taken in the writ petition as well as in the instant appeal, but was not found favor, cannot be re-agitated in an application seeking extension of time to complete the process. There is a complete apathy on the part of the applicant in implementing the order in its true spirit, and there is a lackadaisical attitude perceived from the aforesaid conduct which needs reprimandation. Now, this scrutiny could also be not this session 1, session 2, session 3 game. Nobody knows. But whatsoever technical plea or scrutiny, defect in scrutiny, this was considered to be an apathy and effectively and emphatically turned down by the division bench of this honorable court.
Come to page number 17.
Yes,
I'm sorry, paragraph number 17.
my lord. That's the direction.
Page number 75 of your writ
My lord.
petition.
We would have proceeded to reject the said application, but considering the plight of the
No, no,
candidate.
read from, we are unable to comprehend.
Yes, we are unable to comprehend the stand of the applicant that further written test is required to be conducted when the same was not accepted by the single bench as well as the division bench, and the direction was plain and simple that after conducting the written examination, the answer scripts are to be evaluated and the panel is required to be prepared indicating the successful candidates. But that's what the court wanted to be logically ended and not re-agitated.
So, Mr. Mujumdar, would it be correct to say that on conjoint perusal of paragraph 12, 13 and 17 of your writ petition at page number 75, 74 and 75, according to you, division bench practically turned down the plea of the commission for taking any further examination in respect of the same recruitment examination as has been held on 29/5/2011.
Plain and
That
legal.
is your stand.
That's my stand.
I understand.
But please not permit me to read paragraph 18 at 75 as well. Page 75, paragraph 18. Taking a plea that centers for conducting the written examination was a step taken in due implementation of the order appears to be farcical approach and to some extent in defiance of an order passed by the single bench. However, taking a pragmatic view of the matter, we extend the time for a period of 3 months from date to complete the exercise strictly in terms with the order of the single bench as affirmed by the division bench. But after these caustic observation made by the honorable division bench in relation to the so-called exercise or of scrutiny sought to be undertaken, but I would go to the extent of submitting that this affidavit is an abuse of the process of court.
It's contrary to the direction passed by the division bench.
Not only direction, the division bench castigates the commission. Such scathing remarks is sought to be not obviated by you of this purported explanation.
Then, Mr. Mujumdar, according to you, how the commission justified their action in this comprehensive affidavit?
But that's the stand. Session 1 and 3 were.
No, that I have seen.
That's
How do they justify their action? I have understood that some persons have been left out. Scrutiny of it has been evaluated with the screening test of the answer key of the screening test of
that's
that
also
I have
untrue.
understood.
That's also untrue.
How they have they made any endeavor to justify their action in which according to you contrary to the view taken by the division bench as has been just placed before this court.
But the stand taken in this opposition squarely reflects not that stand of the commission. But that's not a clear abuse. After paragraphs 13, after those page 75 and 76, to come up with a stand and say that on further scrutiny we found this, it's really an abuse of the process of court. And if the commission in that particular page 18, page 13, if that affidavit is the sole defense or not, which was sought to be projected by the learned counsel appearing representing the commission at that stage, that has been taken care of then.
That order is passed on which day?
That was passed on
13 June.
13 June 24.
13 June 2024.
Now, please come to note the bold stand taken at page 20.
13th June 24. Page number
20 now.
20 of
the opposition, comprehensive opposition.
page number 20. 20.
20.
Yes, sir.
Just after the quotation from the division bench order in the middle portion of the page, your lordship will be pleased to find a paragraph beginning with the words by such order. Now, he refers to the 13th June 2024 order of the division bench. Then, by such order, the Honorable High Court has not restrained the recruiting authority from holding the written examination of 73,978 candidates who were successful in the preliminary screening examination held on 28/11/2010 but could not be allowed to sit for the said written examination held on 29/5/2011 due to the technical error of the commission in earlier evaluation of the OMR sheets. Subsequently, the recruiting authority published the notices one after another for holding written examination of the said left out successful candidates who were successful in the preliminary screening examination held on 28/11/2010. On 30th July 2024, that is after the division bench order, the recruiting authority published a notice to complete the first SLST within 10/9/24. Thereafter, by a notice dated 4/8/24, the commission published a list of 24,577 candidates who appeared in the written test held on 29/5/2011 and on 5/8/2024 published a list of 73,978 candidates who were successful in the preliminary screening examination held on 28/11/2010 but could not get the opportunity to appear in the written examination due to technical fault and error in evaluating their OMR sheets of preliminary screening examination.
That is under challenge.
Not how audacious, what more could be a better example of an audacious conduct? Complete disregard to the observation made by the Honorable Division Bench. But each and every sentence or line your lordship goes through, but this will only exhibit not a complete abuse of the process of court.
Yes.
Admittedly, no fresh candidate has been called for or allowed to participate in the written examination except the applicants who appeared in the preliminary examination held on 28/11/2010.
Yes, sir.
But this is more or less the stand of the commission, and the other stand is petitioners had already accepted the notices of the fresh examination. Therefore, they are stopped by conduct from challenging that has already been conclusively decided as so far as the right to challenge is concerned in the two orders passed on August 2024 and October 2024. Now, please come to affidavit in reply to the my lord. That commission had filed an application for modification of the interim order. In WPA 21918 of 24. 191. এটা হচ্ছে তোমার ওইটাতে হাফিজুল হক।
That is scan 4 of 2024.
Yes, scan 4. না, affidavit in reply, not affidavit in reply একটু বার করে দিন না। Affidavit in reply in connection with WPA 2191. Affidavit in reply. But please come to.
You are talking about?
But I am talking about an application being CAN 4 of 2024. Yes, I am grateful to your lordship.
In 2198 21918 of 2024. আগে ওইটা পারবো।
This is that can is also available in the affidavit in reply in connection with the writ petition. Affidavit in reply will also do. Affidavit in reply to the-
রসিদগুলো আলাদা করো। এখন না, এখন না। কিন্তু রিপ্লাই অ্যাপ্লিকেশনটা কোথায়?
But that application is enclosed to the affidavit in reply. And that's annexed to the affidavit in reply. And I'll just bring your lordship's kind notice to that. But the application begins at page 22.
ওইটা বার করুন, না না আমি দরকার ওটা ক্যান ফোরটা বার করুন।
Can 4 is annexed to the affidavit in reply. Your lordship may get it from
I want to see original can 4 of 2024.
in the can. Please come to page 29.
They want modification of Justice Sinha's order.
Yes, this was an yes.
Yes, sir.
Please come to page 29, paragraph 6 of that can.
Yes.
Paragraph 6.
So by filing this order, they want modification of the order date 25/11/2024.
Justice Sinha. There are several other candidates challenging the report of 3-member committee constituted by the order of the Supreme Court filed their respective writ petitions before the Honorable Supreme Court. So many candidates alleging that they are presently working in the respective Group D posts in the different aided madrasas also filed their respective writ petitions before the Honorable Supreme Court. And the Honorable Supreme Court in all pending writ petitions was pleased to observe that interim relief granted by the court in the writ petition being WP Civil number 566 of 2024 will operate even in these matters and thereafter. So many candidates and the writ petitioners before the Honorable Supreme Court who are allegedly working in the concerned madrasas in the Group D posts have been protected in terms of order of the Honorable Supreme Court dated 30th August 2024. Page 51.
Page?
The next page, I'm sorry, page 30. But the third line from the top, now please see the second line. The recruiting authority declared the final vacancy of 297 as on 1/1/2011.
Page number 30, which line, sir?
The second line from
Yes,
the
yes,
top.
recruiting authority. Yes, sir, I got it.
Declared the final vacancy of 297 as on 1/1/2011. The Honorable Justice Amrita Sinha, by interim order dated 25/11/24, was pleased to pass the following order. Not I placed that.
Yes, sir.
The West Bengal Madrasa Service Commission started the process to comply the solemn order dated 25/11/24, passed in connection with the instant writ petition, and intimated the respective madrasa authorities having the reported vacancy of Group D, whether there is any restraining order pending before any competent court of law. In terms of the notice of the recruiting authority, the concerned madrasa authorities intimated the recruiting authority that as many as 9 vacancies are subject matter of consideration before the Honorable Supreme Court in connection with the writ petition civil number 566 of 2024 and other connected identical writ petitions till order dated 6/12/2024. In terms of the order of the Honorable Supreme Court dated 30th August 2024 and subsequent orders passed in writ petition civil number 566 of 2024 and connected identical writ petitions, and all the petitioners therein are covered by the interim order passed in Najma Khatun in writ petition number so and so. The Commission is unable to fill up those posts and also unable to recommend any candidate to those vacancies which are the subject matter of pending writ petition before the Honorable Supreme Court. And until and unless the above mentioned pending writ petitions before the Honorable Supreme Court are disposed of, the present applicants are unable to give effect to the direction as contained in the order dated 25/11/2024. What does that order say? No further examination.
25/11/2024, I believe it is your contention is restricted to the result of the written test dated 29/5/2011.
11. Not your lordship's order was really taken note, was really fructified. Your lordship's order,
What they intend to say, I fail to understand.
they want to conclude the process in terms of the order of 25/11/24. Only keeping those 9 vacancies apart, or not persons who are already working apart.
Are those subject matter of the instant recruitment process?
So there was some writ petition in the Honorable Supreme Court pending. As the Commission says, there are 9 vacancies out of 297. So apart from those 9, they want to comply with the 25th November 2024 order. And the 25th November 2024 order, in line with the Honorable Division Bench, in line with your Lordship's interim order, expressly prohibits any conduct of a second examination. The Commission initially was, please come to paragraph 8. The Commission initially was not a party before the Honorable Supreme Court, and the present recruiting authority has been able to identify so far 9 vacancies out of 297 vacancies which are subject matter of consideration before the Honorable Supreme Court in the pending writ petitions filed under Article 32 of the Constitution of India.
No, Mr. Majumdar, please enlighten this court whether subject matter of the subject, whether the vacancy, which is the subject matter of the vacancy, which is subject matter of
11 process.
subject matter in the subject matter of consideration in the
Supreme Court.
earlier round of litigation before the single bench and in the earlier round of litigation before the division bench is identical with the Supreme
Right.
Court matter.
Yes, please come to that next paragraph 8 I was placing.
Fail to understand what is the stand.
The Commission initially was not a party before the Honorable Supreme Court, and the present recruiting authority has been able to identify so far 9 vacancies out of 297 vacancies which are subject matter of consideration before the Honorable Supreme Court in the pending writ petitions filed under Article 32. Then the next paragraph. The Commission is duty bound to comply the order dated 25th November 24 passed in the present writ petition, but due to the interim order dated 30th of August 24 by the Apex Court, the Commission is unable to comply the same unless the interim order dated 25 November 24 is clarified or modified, keeping in consideration of the order of the Honorable Supreme Court. The writ petitions pending before the Honorable Supreme Court was lastly moved on so and so. Your Lordship may come to the middle portion of that page. There is a sentence beginning with the words, as on 6th December 2024.
Yes.
There were 32 petitions filed by several candidates, including the candidates allegedly working in the post of Group D. And the concerned madrasa authorities having 9 vacancies for the post of Group D intimated the West Bengal Madrasa Commission that the reported vacancies uploaded on 5/10/24 are the subject matter of consideration before the Honorable Supreme Court. From time to time, several madrasa authorities have been intimating the Commission regarding the status of the Group D vacancies, that their respective vacancies are under consideration before the Honorable Supreme Court, where the Madrasa Service Commission is now a party. paragraph 9 on the next page. On 27/9/24, the Honorable Supreme Court allowed the intervention application of the Commission in respect of the writ petition being civil number 566 of 2024, where there is no Group D candidate, but in connection with the identical writ petitions, there are so many Group D candidates who have challenged the order or report of the three-member committee constituted by the order of the Supreme Court. As the connected writ petitions have not been served upon the recruiting authority directly, so the Commission could not disclose the same fact of the interim order dated 30th August 24, passed by the Honorable Supreme Court at the time of hearing of the present writ petition on 25/11/24, and the Commission had no deliberate laches for not disclosing the fact of the interim order of the Honorable Supreme Court at the time of hearing of the present writ petition on 25/11/24. After the issuance of the notices dated 29/11/24, the concerned respective madrasa authorities and the DIAC intimated the present applicants that their respective vacancies are subject matter of consideration before the Honorable Supreme Court in different writ petitions. The Commission is regularly getting letters from the respective madrasas that the respective vacancy are under consideration before the Honorable Supreme Court. As per the cause list of 6 December 24, 32 writ petitions have been filed before the Honorable Supreme Court, and there are huge number of Group D candidates who filed the writ petitions challenging the report of
All those are restricted to 9 vacancies.
9, and they say that other persons have joined in. Huge number of Supreme Court constituted a committee. Who are the persons working? So initially the committee said 9 persons. Then they said no, there are more. So more persons have joined. They said
No,
be that
more persons may join, but vacancy remains constant.
vacancy is 297. But the question before the Supreme Court is whether persons already working should be absorbed in such posts or not. Then the number of
So that is restricted to 9 vacancies, I believe.
9, and probably some more have joined. Yes. That's the Commission stand. Please come to page 34.
32 writ petitions have been filed.
Yes. So that will probably alter the number of vacancies in the long run.
Very good.
But then not the stand taken in the modification application by the Commission is we are trying to comply with the order of 25th November 2024, which is in line with your Lordship's first interim order.
So, Mr. Mujumdar, I believe, would it be your, it is your contention that while while preferring an application being Can 4 of 2024, the Commission has taken, according to you, the shelter of pendency of litigation before the Honorable Supreme Court, and at that time also the Commission has not disclosed regarding the subsequent flaws regarding the selection in the selection process, scrutiny in respect of examination on 29/5/2011. It is your contention.
And not one is filling up of vacancies through issuance of appointment letters. Not appointment follows a recruitment process. Recruitment process will end till the preparation of panel, or not say before issuance of the appointment letter. Not the court restricted this exercise of a stage up to the issuance of appointment letter to the 2011 examinees.
Will you kindly repeat your submission once?
What did the division bench mean? Order mean? The Commission should restrict its exercise apropos the or inter se the 2011 candidates. Don't take any further test.
Absolutely.
So you complete the exercise confining yourself to those persons only.
And publish the result.
Publish result.
You restrict yourself with the outcome of the result of the written test as taken on 29/5/2011 and no others.
And 24,557 candidates were found to be eligible. Don't rope in these 73,000 more candidates. You complete the process. As and when the Supreme Court will decide the fate of the other petitions, that will only determine the number of vacancies. This 297 could be say 230. That will come at the stage of issuing appointment letters. This will not impact the process. The recruitment process will not be impacted by that pending litigation in Supreme Court. এটা তো ভ্যাকেন্সি রিক্রুটমেন্ট প্রসেসটা তার আগেও Commission has declared 297 vacancies in 2010.
I understand your contention that for the sake of argument, even if it is accepted that the commission's plea as has been raised in Can 4 of 2010 is acceptable, it will alter the vacancy as per the order of the Honorable Supreme Court, but it does not touch the merit of the examination which has been completed on 29/5/2011 and which was directed to be completed by publishing the result by the Honorable Division. That is your contention.
Scrutiny,
Very good.
scrutiny.
Come to the next point.
No, that's all.
That's all.
That's all.
Very nice.
And not only to show by way of an example that session 1, session 3 were intermingled with session 2, and session 1 answers key were not correctly evaluated, session 3 answers key were not correctly evaluated.
Mr. Mujumdar, I have some question of
My lord.
Admittedly, the first written test was conducted on 29/5/2011.
10. No, written test, yes.
Written test.
Written
First,
test in 2011.
over who is the direct, you want the publication of the result.
Right.
Now, the subsequent written test was taken on 1/9/2024.
24.
Am I correct, sir? First was taken on 29/5/2011 and the last one was taken on 1/9/2024. Pursuant to the notices under challenge. Definitely, two sets of questions are different.
That's not point taken in the affidavit in reply. It's not a level playing field.
So, my question is whether separate written examinations for the self-same recruitment process is permissible or not.
That was a point taken in the affidavit in reply.
So, why have not you have raised that point?
Yes, not in the affidavit in reply. I have taken the point of Article 14. In a same recruitment process, there cannot be two standards made applicable. One set of questions.
For the Madhyamik examination or higher secondary examination or BA, BSc, BCom examination or of the year 2025, can there be two separate sets of question papers? There may be same set of question papers having different combinations.
Level playing field is not there.
But can it be on different two question papers?
It can never be. No, let's just show the paragraph.
We have not raised the point that why the court will raise that point.
In my petition,
No, it's also there. It's also there. Not only if that entire exercise is gone, not by reason of a division bench order being implemented, then not your lordships are not required to.
No, Mr. Mujumdar, you must not take any chance.
That's very good. Not I stand
Simply
corrected.
because I am asking some favorable question,
No,
it
no,
does
but
not
I
mean that I am.
But I just
I'm leaning in favor of you.
But I no not no. Reply to that.
Mr. Dhar, please pardon me that your judge is a very talkative judge. I am telling.
No. That is the nicest part, because otherwise our profession is very dry. A little bit of the feeling of being wet is this.
I would put it in a different way. A lawyer's wisdom is always a borrowed wisdom.
That
Not
is,
what we borrow it from your lordships.
No. That borrowing is also reciprocal, Mr. Mujumdar, I can say.
the art of originality, there is a saying, the art of originality is basically an art of not telling the source. That is the borrowing. But that is applicable for everywhere and for every.
Any more point, Mr. Mujumdar?
The 2 points not basically
Very
key about supplement.
Now tell me who will argue? Any other?
Oh, not only to show not that the stand taken by commission is incorrect, that session 1, session 3 they were the answers keys of session 1 and session 3 were locked with session 2. That is incorrect because some of the petitioners had also appeared in session 3 examination. 1 and 3 examination, they have also been, their names have been published in the written examination.
Very good.
Now, this is an instance not of one or two employee persons,
What is that?
but this record not when showing that not petitioner number 1 and 8 probably
1, 12 and 53.
1, 12 and 53. Not they participated in
case of Abdul Latif,
session 1 and 3.
1 and 3.
Mr. Majumdar, your clients, that is in WPA 24588, they are successful in that examination.
Yes, not everybody who is approaching the court, co-petitioners are all successful.
They
in
are,
that exam.
they are found to be successful in the written test as held on 29/5/2011.
Subject to correction, they are not successful.
I will hear you, sir. Yes, who will argue? Who will adopt the argument of Mr. Majumdar?
To an extent. Let him, I shall join.
Item number,
You are in.
item number 50, my lord.
Will you
But I-
kindly
Item number-
WPA number, my lord, 26.
Mojumdar has not yet completed. Just to
Oh, sorry.
but I had argued 44 and 46. Item number
No, I have stated that 24588 of 2024 is the lead one.
44. Item 44.
এই এটা কই আমি নোট করলাম বাসুদেব বেজের এটা কই
Mr. Majumdar, kindly place the number and kindly tell me the number.
WPA 24588 of 24.
That I have noted.
Then
Next.
WPA 25438 of 24.
54.
38 of 24.
Next.
WPA 1436. No. Oh, sorry. WPA 21918 of 24.
21.
WPA 21918 of 24.
সাপোর্ট করে পড়বো তো তারপরে তো তুমি অ্যাডিশন আমি
এখানে কোথায় খুঁজে পেলাম না।
তারপরে তুমি আই উইল তোর হয়ে গেছে হয়ে গেছে দাদা স্টার্ট করবো আইটেম নাম্বার 50 ইজ মাইন
Give me a second, sir.
বাসুদেব বেজ আমি WPA নাম্বার বলে দিয়ে শুরু করবো
Yes. What is the case number?
my case number WPA number 26237 of 2024
25.
26
Oh, 26.
237 of 2024 একটু সময় লাগবে
WPA 26237 of 2024.
yes
Mr. Samim.
yes kindly take the writ petition first
দাও ভাই দাও একটু দাও নেব সব নেব 26237.
yes বসো দাদা এখানে বসো এই দাদাকে চেয়ার দাদা
Mr. Samim,
yes
you are SHAMIM.
SAMIM
No, H is absent.
absent
Mr. Samim,
yes
so far your writ petition is concerned, the subject matter of challenge is the notice dated
Dated-
9/8/2024.
yes
And further is your prayer for cancellation of the written examination held on 1/9/2024.
yes
Am I correct, sir?
exactly madam now madam why I asked
এই ফাইলটা দাও গো
file
26237 এইগুলো নামো আস্তে আস্তে এইটা একটু কাছাকাছি রাখো অর্ডার শিটটা এখানে রয়েছে তো টু সিক্স টু থ্রি সেভেন ফাইলটা দিন Mr. Samim, you have heard the argument of Mr. Majumdar.
yes I will repeat will not repeat any single sentence
Please add if you
Yes.
have got anything.
yes
to
yes and I will my lord, never cited the division bench because of that, my lord, already it is cited.
Yes, sir.
Kindly take, my lord, page number 14 of my writ petition. Para 14. Specific averment. What my lord says that it's specifically avoided in my writ petition, original writ petition. Your petitioner, what
Para
is
14 or page 14?
page 14, para 14. In page 14, para 14, bottom.
এটা কোনটা দিলে গো তাহলে? 26237.
Yes, my lord.
Page 14, there is paragraph M and N.
No, my lord. I believe para 14. Page 14, para 14. I believe the other writ petition is given to my lords.
I'm sorry, it is, I'm seeing the AVAB nobody's.
It's original writ petition, my lord.
I got it. Sorry.
It's okay. It's okay.
Yes, sir.
May I start, my lord?
Yes.
Your petitioner state that the action of the commission is also contrary to the recruitment rules. There is no provision to conduct a separate written examination. That's my point. There is no mechanism mentioned in the recruitment rules to meet up the problems of separate examination. The question paper were not same in case of separate examination. An easier question may given in new examination to make a pathway for their favorite examination. In other examination where two or more separate question paper were set, in many cases, normalization mechanism were followed. But in the instant case, there is no such mechanism to put all participants in same footing. In what happened, my lord, in central government, suppose 2 days or 3 days, the examination is conducted. In the case of railway, they adopt a mechanism that's called normalization mechanism. But here, my lord, I will place the recruitment rules later on. Because in that examination, if you want to put separate sets of question paper, then you ought to adopt a mechanism, that a modern mechanism that's called normalization. Normalization, scaling, all are the mechanism to meet up this type of problem. But here the case is that, my lord, they complete divorce the recruitment rules. I will place the rules later on. Before that, my lord, I place my case, my lord, in pleadings, my lord. No such mechanism to put all participants in same footing. Recruitment rules did not mention about any such mechanism, but the commission has taken a separate written test for the 73,978 candidates. The action of the respondent commission cannot sustain in the eye of law. Therefore, said notice dated such and such and the impugned action of the respondent need to be set aside as early as possible by the Honorable Court. Para 15. Your petitioner state that the notice by the commission is bad in law, bad in the eye of law. It is contradicting the order of the Honorable Division Bench. That means 13 June 2024 Division Bench order. The petitioner state that it has been decades since the examination was held. The writ petitions filed before the Honorable Single Bench was with the prayer for publication of result, which has not been complied with. The petitioners, along with several same-footing candidates, are suffering due to the delay, and holding another written test would create further complication and delay, and the petitioner will be deprived of the opportunity. The commission cannot conduct a fresh examination of same candidate. The examination process need to be declared as bad in law. Now, my lord, what was the commission stand in earlier before the division bench, my lord, through CAN 20, which is annexed with the comprehensive affidavit. My lord, kindly take the comprehensive affidavit.
Comprehensive affidavit লাগবে কোথায় গেল? Comprehensive affidavit কোথায়?
Comprehensive affidavit.
নামালে ওটার মধ্যে আছে।
No.
24588 এর মধ্যে আছে।
একটাই স্যার। Page number 152.
24588 এ পাঠাবো। কেন খুলতে বলেছি দেখেছো তো? আজকেই খুলবে সব। Yes.
My lord, kindly take page number 152. On 13 June 2024.
Give me a second. Yes.
On 13 June, my lord, this application was moved before the division bench. In connection with MAT 907, CAN 20 was moved before the division bench. What was the pleadings in this CAN? That is important. 152, page number 152. We start from page number 152. I just skip the para 1 and 2. Para 3 is very relevant.
Yes.
I read. The appellant, that means the appellant commission, state that on 19 September 2023, during the pendency of such application, the had already taken a policy decision to conduct a fresh written examination of total of 1,164 candidates. The commission take this policy decision. My first question is that from which provision of law they got this power, empowered? How the commission is empowered to take a policy decision after finishing everything, they will conduct a further written examination. Now, a very interesting fact came out thereafter. Of conduct a fresh written examination of a total of such and such candidate, that is 74,618 eligible candidates, which were left out along with 26,444 candidates who had already appeared in the written examination of Group D held on 29th May 2011. The appellant state, the very next paragraph, the appellant state that upon passing of the order dated such and such, the following step has been taken to comply with the order passed by the Honorable Court.
Mr. Samim,
Yes, my lord.
so far as paragraph number 3 is concerned,
Yes.
what is the stand of the commission? The commission
Commission,
intends to take examination of all the candidates.
no. Kindly take this. May I read again?
Commission had taken a
The
policy
it
decision.
will clear by the last two lines. Page 156. It is cleared by the last two lines. They want to conduct further examination, although this is not a very clear, but the intent is that the spirit of this paragraph is that they want to conduct fresh examination in respect of 74,000.
Sir, just a minute, sir. Had taken a policy decision to conduct fresh written of a total of no, Mr. Samim. Paragraph 3 says such and such had taken a policy decision to conduct fresh examination of a total of 1 lakh and what candidates.
Yes.
So their intention is to take fresh examination of the candidates of 1 lakh and what? That is 74,000 and odd eligible candidates which we have left out along with.
That
So
is,
they intend to take the fresh
There are-
examination.
thereafter, the sentence is not yet completed. That is, i.e., 74,618 eligible candidates which were left out, along with 26,445 candidates who had already appeared. That means who already appeared, which will be more clear because of they give a tabular chart.
Mr. Samim, paragraph 3 clearly indicates that the commission had taken a policy decision to conduct a fresh written examination of total 1 lakhs and odd candidates, which includes 74,618 were left and plus 26,448
Already appeared.
already appeared.
So
Sum total will come
that is the number. Because of that, kindly take page number 4 of this comprehensive.
Just a minute.
Before that, kindly, if my lords wants a list of date, that will be give a clear picture to before this court, my lord, page number 4 of this comprehensive affidavit.
Just a minute, sir. 74,618, 26,447, 6, sum total comes to 1 lakh 1,063, 64.
Kindly,
That is they intend to take a
kindly,
fresh examination.
yes, no. Kindly take, my lord, page number 4 of this comprehensive affidavit. Page number 4.
Just a minute.
It give a list of date that will give the clear picture of this about this matter. How this matter is cropped up. Para 5.
Page number?
4 of this comprehensive. Because this is, it will help the court to ascertainment the fact. List of dates. The first entry, that is 27th March 2010, that is the publication of the advertisement date. Second entry, the commission conduct preliminary examination on 28th November 2010. The third entry, about 26,000, which my lord asked me about this 26,000. On 29th May 2011, already 26,445 candidates, they appeared in the written examination. There are second stage. So they appeared. What they did, they says, I will read the whole application. Because of that, what is the necessity of the reading, that will give the clear picture. I just put this list of date. Why? Because of that, it will give the clear picture. On 12 March 2014, the High Court order. Thereafter 9th December 2015. Thereafter 14/3. I just skip over. They even quoted in their tabular chart, and kindly take entry number 13. They even took cognizance of the division bench order. They already complied the division bench order by giving the cost portion. They can't take the contrary stand now. They already complied the order because they already gave the 2 lakhs cost. Now, after that, because this order came out after this application, moving this application, I will tally this application along with this comprehensive affidavit. Why? Because they took, which is already the decision is taken by the division bench. Now they wants to re-agitate the same issue. Even the paragraph is total the same. I will compare this to affidavit, this application along with this comprehensive affidavit. I will tally it. That's why I placed this application. Now, my lord, kindly take para 5.
Para 5 of what?
Of this scan application, page number 158. Page number 158. 8. They are comprehensive. The appellant further state that they have issued letter dated such and such to the district magistrate seeking for the availability of examination center to enable the appellant to conduct examination shortly. That means fresh examination of left out candidate. Such information regarding the availability of examination center is of vital importance for the issuance of admit card. Copy of the letter such and such. I just skip this portion, para 5, para 6. Now kindly take paragraph 8 and 9. 7, 8 and 9.
Page number?
160. Got it, my lord?
Yes, sir.
Para 7, it is stated that as a result of aforementioned pre-scheduled business of appellant, that is conducting recruitment process of assistant teacher, the appellant have been under immense pressure and were unable to complete the entire recruitment process for the post of Group D in terms of order dated 12 September 2023. That paragraph 8, that the order dated 12 September 2023 is due expire on 11 March 2024. However, the appellant, despite the best effort, were unable to complete the entire process of recruitment of Group D candidate. Were unable to complete the entire process of recruitment of Group D candidate within such time frame as directed by this honorable court. Paragraph 9, very interesting. The appellant further state that they have received letter from the district election officer stroke district magistrate for the requisition of numerous staff of the West Bengal Madrasa Service Commission for the upcoming general election to the Lok Sabha 2024. Copy of the letter received from the district magistrate election officer stroke district magistrate is annexed here too and marked with letters such and such. Now, my lord, kindly turn page number 19. Now their stand. What is their stand? Same stand. Para 19. M. Paragraph M. paragraph 19. That after 12 September 2023, the commission again started process of re-evaluation of the OMR sheet. My second question, my first question was that from where they got this power to conduct a further written examination, because there is no such normalization procedure, because separate set of question paper. That is the first points of agitation. Second point of agitation, this re-evaluation. From where they got this power of re-evaluation of OMR sheet? Because if they want to re-evaluate the OMR sheet, there must be some statutory backup, because division bench is very clear. And
Give me a second. Yes, Mr. Sami.
yes, Margaret. So there is no such provision of re-evaluation of OMR sheet. My second point. Re-evaluation of OMR sheet of all the session and preliminary examination for the
Second or third point.
third
Your first point
yes,
was violation of recruitment rules.
yes.
Your second point
There-
was no mechanism has been followed for normalization of the recruitment process.
There is no rule regarding second time holding of the written examination. So
And
there is
third is no power to re-evaluate the
the
OMR.
OMR. Yes,
As
I'm
per
grateful.
the
Yes,
recruitment rules.
yes, I'm
Those
grateful.
are the basically 3 points.
Three
you have
points. I will come up another points also.
Very good.
Number re-evaluation of OMR sheet of all the sessions of the preliminary examination for the post of Group D held on such and such date with proper answer key of those respective session. And thereafter, it was detected that 73,978 candidates who had appeared in the preliminary screening examination for the post of Group D on such and such date were eligible for written examination held on such 29th May 2011, but had not allowed to sit in the said examination held on 29th May 2011 due to the technical error of the commission as stated herein above. The commission could not complete the whole process due to Lok Sabha election 2024 after completion of the Lok Sabha election 2020. The same point, because of the earlier occasion in Can 20, they took the same point. Here also, they took the same point. And the fate of the Can 20 is already decided by the division bench. How can they re-agitate the same point which is already decided? That's why I compare this paragraph with the earlier application. May I place the division? Sorry.
Are you in a hurry, Mr. Samim?
No, my
Let your judge note.
because I কিরকম বদমাশ না
So, Mr. Samim, would it be your contention that the point or the defense has taken in this comprehensive affidavit is, since it is identical with CAN 20 of 2024, in connection with MAT 907 of 2018.
Yes,
And since it has been, those issues have been decided by the division bench,
it is.
though the defense taken by the commission operates as a res judicata.
Yes.
That is your
That-
contention.
yes, my lord, that's my point.
Let me note, sir.
Yes, my lord. And now, my lord, the third point is, fourth point is that, my lord, how the
Yes, sir. Next.
my lord, now, my lord, I wants to refer the rule position. What is the rule position? This is the 2010 rule, my lord. Just a second.
2010
10 rule. This rule called, because this selection process first SLST 2010 non-teaching staff is the rule regarding this matter.
এটাতে মার্ক করো, ওই মার্ক করে রাখো WPA 26237 বলে, ওই যেটা দিচ্ছেন উকিল বাবু, নাহলে খেয়াল মনে রাখতে পারবো না, ওটা নোট করা হবে। ইন WPA 26237 of 2024.
Yes, my lord. রিপোর্টেড হয়ে গেছে রে, রিপোর্টেড পোর্শনটা নিয়ে এলেন, আনরিপোর্টেড অনলি। রিএভ্যালুয়েট করা যায় না। লিখেছে, চুপ করো।
West Bengal Madrasa Service Commission recruitment, selection and recommendation of persons for appointment and
And-
transfer to the post of teacher and non-teaching staff,
Rules 2010.
2010.
Yes.
Very good.
Kindly take note of the rule, that is rule 12 onwards, my lord. Specifically, I want to canvass rule 14, 15, 16, 17, specifically rule 17.
Chapter 5.
Yes, my lord. Chapter 5 onwards, my lord.
Which rule you want to refer, sir?
Rule 11 onwards, my lord, because that is rule applicable to this.
That is
process.
chapter 5.
Yes, my lord.
Chapter 5 and chapter 6. I
Yes,
think.
my lord. Chapter 5, chapter 6, and chapter 7. Specifically, chapter 7 is very important because there is about evolution. There is no such provision of
Chapter
re-evolution.
5, chapter 6 and chapter 7. Yes.
My lord, rule 11 says about the form of application and fees thereof. I just skip it for the time being. Rule 12 is about submission of application. And rule 13 is processing, screening of application. For the time being, I just skip it. Now, my lord, rule 14, issuance of admit card. For the time being, I skip it. Rule 15 is very important.
Yes.
Rule 15 says about arrangement of written test, not tests. In singular form. The commission shall arrange for written test, not tests, under its direct supervision and control. The commission shall determine the scheme and syllabus of the written test, not tests. Prepare question paper and distribute the same to the examination venue through the custodian appointed by the commission. The commission shall appoint paper setter, moderator, observer, approve the list of examiners and experts, fix the rates of remuneration for paper setters such and such. The commission shall determine the number of papers for the written test, content each paper, duration of examination, and other matter relating to the state region such and such. Rule 16. Holding and conduct of written test. Again, written test. The commission shall hold written test of all the eligible candidates. They are also the written test, not tests. The commission shall decide the procedure and the manner of conducting the state region area of level selection test and the prepare details instruction in this regard in accordance with the provision of the act and the rules made thereunder. The commission shall select examination. For the time being, I'll just skip it over. Rule 17, that is evaluation. Very interesting. Evaluation of answer scripts sheets. The commission shall get the answer scripts stroke sheets of the written examination evaluated by the examiners computer-based technique and prepare a evaluation sheet, medium, post, subject category, and gender-wise on the basis of such evaluation. Now, preparation of list of candidate for percentages. After the evaluation of answer sheet of the written examination, the commission shall prepare medium, post, subject-wise, categories. There is the provision. So there is no such provision about second time written examination. That's my
That
point.
is called multiple test.
Yes, it never be a multiple test. If you want to adopt the multiple test, then there must be some provision in the rule itself. It is happened in the case of railway examination. It's happened in the case of staff selection examination. Because in that type of examination, there is in the advertisement as well as the rule, there is must be the specific provision. In that provision also they says we adopt the process of normalization or scaling. So there is no such mechanism of second time test. And one go, you ought to take the written examination. It might be the multiple center. There is another point is that there is no such provision of re-evaluation. Because
Give me a second.
যা বলছি পরে শুনে নেবে, পরে শুনে নেবে, পরে শুনে নেবে, নাহলে পয়সা লাগবে।
The recruitment rules does not
Confer any
prescribe
right.
any re-evaluation.
My 2 point is there. In recruitment rules, there is no such provision of second time written examination. There is no such provision of re-evaluation of OMRC. Because re-evaluation, there is a hell and heaven difference between evaluation and re-evaluation. Because this is a statutory body. And statutory body, this statutory body, West Bengal Madrasa Service Commission, is empowered by the
The
statute.
rules are to be
Yes.
finalized before
Yes.
holding examination.
Yes, this rule framed by the state authority, and they, by adopting this rule, they process this selection process. So being a statutory authority, they can divorce the rules. Divorce the rules amounts to the.
Understand. What is your next contention, Mr. Samin?
My next contention is that, my lord, I just summing up is, my lord, that is all, my lord. I just summing up this, if my lords want, because of this is a settled proposition of law that re-evaluation is not permissible, because in our division bench hold it very recently in upper primary examination, the re-evaluation is not permissible if that is not backed by the statute. That is, I want to refer it. I will refer it later on if they wants to contradict it. Say,
Please refer so that I can.
আমি দিয়ে দিচ্ছি যাইবে আমি জাস্ট সামিং আপ করে দিয়ে দেবো ওকে ওকে ওকে
I think it's pretty clear that by the using the word evaluation, my learned friend should indicate that.
If it is not clear, it will go in your
yes your term.
Something you need to make.
Maybe. If the argument of Mr. Samimi is not convincing, it will
Yes,
be
you will
in your-
agitate it. You will agitate it. You will agitate it.
So, Mr. Samim, please sum up.
Yes, my summing up this, my contention is that in 3 proposition of law. First is that, my lord, there must be a level playing field. Because in our country, there is no such right of employment. Equal opportunity in public employment, that's the fundamental right. If suppose 2 examination was conducted, in one sets of examination, easier test might be happen, and suppose the Article 12 authority might choose their favorite candidate in that sets of examination. So that's why the modern technology adopt, that is normalization. So it is because a huge number of participating candidate in that selection process might be happen. So that's why normalization process was adopted in that type of examination. But here there is no such provision, so that is not permissible. Second thing is that they did it. That means they divorced the rules. If they did it by divorcing the rules, it amounts to not giving the equal opportunity to all the candidates. it is liable to be set aside their action. Third point is that, my lord, that is, if they want to re-evaluate the OMR sheet, that must be backed by the statute. There is no such express provision of law to re-evaluate the OMR sheet. And my fourth point is that regarding the second time written examination, already division bench hold it, that is not permissible.
judicata.
So that is res judicata. That's 4 points. That's right. That's extremely grateful, my lord.
Any other want to join in favor of the writ petitioners?
Date. Serial number 54.
Kindly place the case number. WPA
9578.
9578.
We have assailed the notice.
9578 কি ট্যাগড হয়েছে?
Now, is yet to be tagged.
দেখি এটা আমার দিন একবার কি আছে দেখি।
I don't have the copy of the affidavits that they have used since it has come for the first time.
Subject matter is same.
Same subject matter. Only thing is that if I get a copy of the affidavit, then I can address the court whatever points they have taken on that. The affidavit that are used by the commission and other respondents in other matter must be the same stand in my matter also.
Mr. Dhar, please,
As far as if you want the
9578. 9578.
Item number 49.
I have absolutely no difficulty. I can give a soft copy because I use the soft. Soft copy. No,
9578.
because
You'll
fundamental.
get your chance to make your
It
submission.
has to be tagged and I'll get a copy of
I'll tag it today. Please remain, either you or your
Yes.
junior remain in court. Mr. Bhattacharya, you are appearing in?
Item number 49.
Kindly tell the WPA number, sir.
The copy is ready. That's good.
2609.
Yes, sir. ওনার নামটা কি?
Right, Samim.
Madam, two Shami, Firdos Shami, this is Shami Mohammed.
But you are minus H.
Minus H.
Mr. Bhattacharya is appearing in?
For the petitioners in item number 49.
What is the WPA number, sir?
26090 of 2024. Chalo, join the short doc.
Zero 90
It is right.
2020. একটা নিয়ে নি।
Start.
No, we are still 22 minutes are there. একটা লাইন লিখে নাও তো। উনি হচ্ছেন মিস্টার শামীম আহমেদ না? আর এটাতে একবার লিখে রাখো এই WPA Mr. Bhattacharya is
For the petitioners, my lord, in WPA 26090.
yes, sir.
My lord, please come to my writ petition. I
You
am.
have you have heard the argument of Mr. Mojumdar and Mr. Sarathi.
I know, my lord, what they have said. But I think, the other matter, my lord, the GTA matter was going on in the other court.
So please don't repeat. If you
kindly
want to
come
add
to
something,
Kindly comes to page 55 of my writ petition. But first, I invite your lordship to page 53.
what is your flag left?
Page 53.
Yes.
My lord, by this time, your lordship is aware that there was a written test, first SLST non-teaching, held on 29th May 2011. That your lordship has been not aware by the submissions made by my predecessors, who were making submission, my learned senior friends. This document says that the list of such and such number of candidates kindly marks the number 24,577 who appeared at the written test of first SLST non-teaching 2010 held on 29/5/2011 is uploaded on the website of the commission. These 24,577 candidates who appeared in the written test group D held on this will not have to appear in written test again. Has my lord got it? So this is 4th August 2024. A Bengali document also was published on 4th August, page 54.
Saying that appear korte hobe na.
We are those candidates. Our names figured in this 24,577.
Of course.
14 persons. Now, my lord, page 55 kindly comes now. That is the subject matter of challenge in the writ petition. Poschimbango Madrasa Service Commission দ্বারা আয়োজিত such and such 28/11/2010 তারিখে অনুষ্ঠিত প্রিলিমিনারি স্ক্রিনিং টেস্টে যে 73,978 জন প্রার্থী যোগ্যতা অর্জন করা সত্ত্বেও 29/5/11 তারিখে লিখিত পরীক্ষা দিতে পারেননি তাদের নাম ও রেজিস্ট্রেশন নাম্বার পশ্চিমবঙ্গ সার্ভিস কমিশনের ওয়েবসাইটে who were eligible but could not appear লিস্টে দেওয়া হলো। এই 73,978 জন প্রার্থীকে আগামী এত তারিখে পশ্চিমবঙ্গ মাদ্রাসা সার্ভিস কমিশন দ্বারা পরিচালিত লিখিত পরীক্ষায় দিতে হবে। So this is 24,000 will not have to sit. 73,000 will have to sit. Now, this stand is in pursuance of decisions which your lordship will be finding starting from page 49 of my writ petition. Please see 30th July 24.
The instant petitioners are
the candidates.
Are amongst the 73,000 and
no, are amongst the 24,000.
24,000 and all.
We are covered by 4th August. We are not covered by 5th August. We are not.
You are the successful candidates on the of the examination held on 29/5/2011.
Mind. Successful, my lord, we were not called upon to sit for any examination. We are covered by that decision communicated on 4th of August 2024.
No,
Yes, we are successful.
that's all.
Now, my lord, please pardon me.
Page number?
My lord, first is page 49. This is for general information that in terms of order dated 23rd July 2018, in WP number 1722 of 2018, my lord, that 1722 order, my lord will be pleased to find at page 36 of the writ petition,
I've gone through.
which was affirmed by order dated 13th June 2024. Now, my lord, pausing here for a moment, 13th June 2024 is an order passed in a disposed of appeal in connection with a can taken out by the commission. In connection with a can taken out by the commission.
36/2024 order.
Yes.
Can is for extension of time.
Yes. Now, my lord, pardon me for saying this. The original order of the appellate court is at page 67 of is at page 39 of my writ petition. The original order made by the Honorable Division Bench in the appeal carried by the commission from the order of page 36.
ওই ফাইলটা দাও 24588 এর পিটিশনটা দাও 10 জায়গায় দেখে লাভ নেই ফোর ফাইভ অরিজিনাল পিটিশনটা খালি আমার দিকে Single bench passed the order on 23/7/2018.
My lord,
Bhattacharya.
my lord, 23rd July 2018.
The coordinate bench order.
Yes.
Coordinate bench order.
Yes.
And the judgment or the order dated 13/6/2024 is the first order passed by the division bench.
No.
No,
That was the last order.
I'm sorry.
Page
Then
30, page 39.
it is on 4th February 2020.
24th February 2020 is the initial order.
4th February.
So, what, my lord, I need not, my lord, trouble your lordship, apart from saying that the direction made by the coordinate bench in the writ petition carried by Showman Malakar is appearing at the internal page 2 of the order. And the direction was to forthwith intimate to the writ petitioner the result of evaluation of these answer sheets, and if he is qualified, then to prepare the panel in terms of Rule 18. If he is eligible as qualified candidate in terms of the.
You are reading the order date 4/2/2020.
Well, I am reading the order dated 23rd July 2018.
Single bench order.
Yes.
Oh, I see. Why are you referring?
Why? Because, my lord, the direction of the court. What was the direction? The direction of the court was, my lord, I am reading from internal page 2. Accordingly, the present writ petition is disposed of after recording that the writ petition
It has been placed by Mr. Mojumdar.
Yes. Now, my lord, this was the direction. This direction was
Has been
ultimately,
affirmed
my
by
lord,
the division bench.
at page 39.
That is in on 4/2/2020.
Yes.
Only modification is extension of time.
Then the question of any examination, re-examination, subsequent examination, nothing. Please come to page 42. It has been argued, my lord, I am trying to just show your lordship, my lord, that the endeavor by the commission
Hmm.
endeavor of the commission as would appear from paragraph 9 of the order dated 13 June 2024.
Mr. Bhattacharya, please listen me. Thereafter, please answer. The coordinate bench directed the commission to evaluate the answer sheets and publish the result.
And in the event of thing, in terms of the rule to proceed.
Absolutely. Such order has been affirmed by the division bench.
My lord.
Only modification is extension of time by 6 months. By subsequent orders on the basis of several CAN applications, interlocutory applications, the division bench time to time extended the order time.
Yes.
This much.
Last extension was 12 September 23, as would appear from paragraph 7 of the last order, my lord. 13 June 2024 order, if my lord kindly sees, my lord.
Yes.
Page internal paragraph 7 and 8.
Huh.
Then, my lord, then this specious plea regarding a fresh examination and conduct of examination was taken before the honorable division bench. Paragraph 9. Now please see internal page 4, third line from the top. A litigant is not permitted to prevaricate its stand at different stages of the proceedings.
Which portion, sir?
Third line from the top at internal page 4.
Internal number page 4, yes.
As my lord very kindly got it, my lord, a litigant is not permitted to prevaricate its stand at the different stages of the proceedings. If the plea was taken in the writ petition and the court ultimately disposed of the proceeding, even without recording any finding thereupon, it is deemed the said plea has not been accepted by the court and deemed to have been rejected. Even before the appellate court, it does not appear that any such plea was taken or argued at the time of hearing, and the order of the single bench was affirmed with modification to the effect that the time limit for completion of the entire exercise is extended for a period of 6 months. Interestingly, the first application for extension was disposed of, extending the time for a further period of 6 months, which necessarily implies that such plea which is sought to be projected for the first time in the instant application was not pressed and or pursued, as the authority decided to complete the exercise in due implementation of the directions passed by the court. A plea of res judicata also appears in the instant case. The plea which ought to have been taken or was taken and the decision have been taken finally, it would be deemed that the said issue has been decided finally and cannot be reopened at the subsequent stage of the proceeding. We are conscious that the plea of res judicata not only applies between two proceedings but has equal applicability at the different stages of the same proceeding. The principle of res judicata is based on public policy. The fundamental policy of the country is to bring every litigation to its logical end and shall not allow the litigation to continue eternally. The plea which has already been decided or comes within the purview of explanation appended to section 11 of the Code of Civil Procedure cannot be allowed to be re-agitated at the different stages of the proceeding as it is set at the rest at one point of time. The cascading effect of permitting, etc. Now, we are unable to accept the contention that a plea was taken. There has been a large discrepancy in the scrutiny process, and therefore the authorities have decided to make a fresh scrutiny so as to invite. We are unable to accept. Not the Honorable Division Bench, its order cannot be referred to as a ruse as if the Honorable Division Bench permitted conclusion of the process in the manner ordained according to the Commission, which is apparently not appearing from the order. Milord, please see such plea having taken in the writ petition. Milord, I am reading paragraph 13. Discrepancy in the scrutiny process, and therefore the authorities have decided to make a fresh scrutiny so as to invite several other eligible candidates to participate in
So,
the
Mr. Bhattacharya, I believe it is your contention. The defense which has been taken in the comprehensive affidavit
Yes.
in connection with the instant writ petitions have already been considered by the division bench while passing this.
Sir, with greatest of respect to my lord, with greatest of respect to my lord, please see just for a moment paragraph page 49. Before since your lordship is looking into page 46, please see page 49.
Yes, sir.
This is for general information that in terms of the order dated 23rd July 18 in WP number such and such, which was affirmed by order dated 13 June in MAT of the Honorable Division Bench. 13 June is the order that your lordship is looking at.
So practically,
planned to
according to you,
complete.
Mr. Bhattacharya, the finding of the honorable division bench operates as a res judicata
Yes,
in connection with their defense.
it does. Finding of the Honorable Division Bench is that this stand they cannot take first, and therefore any endeavor by them to conduct a fresh selection by way of 5th August 2024 cannot be countenanced because the division bench itself did not permit that and saddle them with costs of 2 lakhs. Please see. Now, I respectfully, Milord,
Give me a second.
I'm sorry, sir.
Yes.
Now, please see categorically paragraph 17. What is the division bench's verdict? That's the order of the Honorable Division Bench, and they cannot interpret it to suit their own convenience. We would have proceeded to reject the said application, but considering the plight of the candidates who have participated in the written examination and because of the careless conduct of the authorities, their fate is still in the lurch, or in other words, uncertain. We feel that the authorities must act strictly in terms of the order passed by the single bench as affirmed by the division bench. We are unable to comprehend the stand of the applicant that further written test is required to be conducted when the same was not accepted by the single bench as well as the division bench, and the direction was plain and simple that after conducting the written examination, the answer scripts are to be evaluated and the panel is required to be prepared indicating the successful candidate. So the fresh written examination was rejected.
So, Mr. Bhattacharya,
My lord.
I believe it would be your contention. Kindly listen me. That in view of the decision of the honorable division bench, the division bench did not permit the commission to raise the plea that a large discrepancy took place in the scrutiny process, and therefore the decision of the authority to make a fresh scrutiny is no way permissible. I believe it is your contention.
And
So-
was rejected.
So I believe it is your contention that when such plea was not considered favorably by the division bench as submitted on behalf of the commission, that plea cannot be taken, or that plea cannot be re-agitated in course of the instant writ petitions.
plea cannot be re-agitated by taking the shelter of the Honorable Division Bench's order. Please see page 49.
That I'm saying.
They have said that in accordance with the
So
Honorable
practically, according to you, by this order, while disposing the can, Honorable Division Bench has barred the commission
from
to
holding a
take
fresh
holding
test.
cross examination.
Yes,
That's all. I understand.
but on the face of it, paragraph 17.
Anything you like
So,
to add?
yes, two more.
Very good. Asu, check them.
At 48, but I have filed one
Wait. Why supplementary debit? Why am I making unnecessary
No,
complication? This court has hard